Hello viewers, today we will discuss the topic cybercrimes and the adequacy of the existing laws. We are living in an era of internet and information technology. The information and communication technologies have been revolutionized in the past 2 decades. The invention of the computer has been a boon to the human community. Students, lawyers, businessmen, doctors, teachers and all other professionals. But the computer as an instrument to aid criminals is also on a rise in a broad spectrum of areas. It is a cause of worry as unauthorized access, damage to property, theft and distribution of obscene and indecent material are well-known crimes and has assumed different dimensions with the emergence of the internet. The internet, with all the benefits of anonymity, reliability and convenience, has become an appropriate dealing place for persons interested in making use of net for illegal gainful purpose, either monetary or otherwise. The term cybercrimes could reasonably include wide variety of criminal offences and unlawful activities related to or having connection to computers. The potential scope is even larger when using the frequent components or substitute term computer related crimes. Cybercrimes are becoming reality in India, as it is very often we come to know instance like this, that Indian airline was defrauded of several lakh rupees when open-ended tickets for the shorter sector were issued in a fictitious name by some staff members. Another example is that the accused has misused an AIMS doctor credit card to view pornographic site on the net. He gained around rupees 10,000 per month. That the post-Pokhran hackers gained access to the Bhabha Atomic Research Center computer system and pull out the vital data. Generally, terrorists preferring internet for free discussion, emails, etc. for propaganda, recruitment, fundraising and plannings. Now, we will discuss the existing penal law and challenges of the modern crimes. Ordinarily, the law keeps pace with the technological change in the society. However, the rapid technological development like internet clearly threatens to leave the law behind. To the technological expert people, internet is a global network of computers based on TCP, IP and other high-speed communications protocols with thousands of nodes and millions of users. But for the rest of the world, the internet is an exciting new way to communicate. The main uses of the internet are to exchange electronic mail transfer files between computers and remotely accessed host computer. The internet is truly emerging a mass media. In the present era, the cheap and widely available services of computers has made copying easy and perfect. Within a minute, thousands of perfect copies can be made with the help of personal computers. Add to this internet provide access to the material that is worth copying. The transmission and exchange of this wide variety of information without any territorial limitation and the open and unregulated nature of internet provide fertile ground for the criminal enterprises. Since the internet's basic purpose is facilitation of communication of all the traditional crimes such as conspiracy, solicitation, securities, fraud, espionage can be committed via internet. But the big question is, can the novelness of internet be dealt with the help of all the present law in force? There is a penal law was adopted in 1860. The Indian Evidence Act in 1872 and the Code of Criminal Procedure in 1973, and the internet is something of recent origin. For the application of these existing laws, the territorial limitations are there, but these limitations are irrelevant in cybercrimes. This poses serious question with regard to the jurisdictional matter that are fundamental for any criminal proceeding to take place. These fundamental aspects pose some important questions. What? That whether the relatively new cybercrimes can be dealt with effectively by present laws in force, whether irrelevance of territorial jurisdiction may be hindrance in the way of existing implementation authorities, it must be realized that these challenges are fundamental and it's essential to understand the nature of these crimes. Only then we can move ahead. So the basic object of this lecture is to understand in the concept of some of the most common cybercrimes, to examine whether the existing penal laws are sufficient, to find out whether there is a need to have an international legal regime governing and regulating internet. To go further, we must make it clear that our Indian Penal Code 1860 has no concept and definition of cybercrimes. Reason being, at the time of framing IPC, there was no concept of computers. Till the passing of Information Technology Act 2000, Indian Penal Code was the only law applicable to the cybercrimes. In fact, IT Act was enacted with the prime objective of providing legal recognition for transaction carried on by means of electronic data interchange and other means of electronic communication. That is, to boost e-commerce. Apart from this, Section 77 of Information Technology Act 2000 clearly provides that penalties under the Information Technology Act 2000 does not release the offender from liability under any other law. Hence, the substantive provision of IPC still do apply to such offences. Then we will discuss the fundamental principles of criminal liability. The fundamental principles of criminal liability is that there must be a wrongful act, that we call this actus reus. Actus reus means confined with the wrongful intention, which is mens rea. Before a person is made liable, this principle is embodied in the maxim actus non facit reum nisi mensit rea, meaning an act does not make one guilty unless the mind is also guilty. Now, let us examine this principle in the context of cybercrimes. Actus reus, in computer crimes, the element of actus reus is easy to identify but not so easy to prove. Some of the example of actus reus in the computer crimes may be identified as doing something which makes a computer to function, touching keyboard and mouse, etc. Then trying to access stored data by using an unauthorized person's password to log into any computer main server, hoping to get some details. Then using internet to attempt to gain access signal pass through various computers. Each of these computers is made to perform a function on the instruction which the person gave the first computer in the chain. Each activity constitutes actus reus. Then we will discuss mens rea. The second element of crime, mens rea or guilty mind, may comprise a number of different mental attitudes including intention, recklessness and negligence, etc. In computer crimes, an essential ingredient for determining mens rea on the part of the offender is that he or she must have been aware that at the time of using a computer that the access was unauthorized and the hacker intended to secure unauthorized access. However, this intention to secure access need not be directed at any particular kind of program data. It is enough if hacker intended to secure access to programs or data. The recently passed Information Technology Act 2000 provides legal recognition for transactions carried out by the means of electronic communication or e-commerce. The Act seeks to protect the advancement of technology by defining crimes, prescribing punishment, laying down procedure for investigation and forming regulatory measures. Many electronic crimes have been brought within the definition of traditional crimes too by suitably amending Indian Penal Code 1860, the Evidence Act 1872 and facilitate admissibility of evidence in fighting electronic crimes. Then we will discuss the type of computer crimes. Cyber crimes or computer crimes are crimes related to information technology. Certain crimes like defamation, cyber frauds, freakers, hacking, pornography, viruses, cyber stalking, violation of privacy, copyright violation, cracking, etc. Crime committed through computers and internet can be classified as some conventional crimes like defamation, forgery, harassment, fraud, and some financial crimes committed with the help of computers. Then crime committed on a computer network like hacking, denial of services. Then crime relating to data alteration, destruction of data, theft of internet hours, etc. The first we will discuss what does cyber defamation means. Next to the life, human being cares most for his reputation. Reputation is in fact a great internal force in the mind of every man, impelling to do great things. To save this important facet of human personality, Section 499 of IPC defines defamation as whoever by words either spoken or intended to be read or by signs or by visible representation makes or publish any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is said except in the cases hereinafter accepted to defame that person. Here we can observe that in this definition no specific mention has been made with regard to electronic publication. But in this era of computer technology, defamation implies anything which we read, see or heard with the help of computers. This is a plethora of issues related to the internet defamation. The most important issue of whether writing on the internet amounts to publication or not. Some of the common example of cyber defamation includes defamation through email. Email is remarkably quick and easy to use method of correspondence. It has close resemblance to spoken conversation rather than written format. This electronic interaction combines a sort of deceptive distance combines with a kind of equally deceptive intimacy. Hence, email senders are dangerously prone in making defamatory statements. World Wide Web is another component of internet. It combines a user-friendly interference with the freedom of articulation and information. Here, people having no knowledge about defamation write defamatory statements without appreciating this potential liability. Section 4 of the Information Technology Act 2000, read with Section 499 of IPC, covers the offence of cyber defamation. So, if any defamatory information is sent through internet or email or that room or chat board, it may well be covered as publication under Section 49 and would amount as a cyber defamation. Then we will discuss harassment and cyber stalking. A stalking can be defined as a willful conduct involving repeated or continuing harassment of an other individual that actually causes the victim to feel terrorized, frightened, intimidated, threatened, harassed or molested, and that would cause a reasonable person to feel so. Cyber stalking is an extension of physical form of stalking, where the internet is used to pursue, harass or contract in other unsolicited fashion, though the cyber stalking does not involve any physical contact. Yet, stalking through the internet has found favor among the offenders for certain advantages available, like ease of communication, access to personal information and anonymity. Online cyber stalking is more dangerous as there are no territorial limits. A person in any part of the world may harass a person at another part of the world. Then we will discuss Section 503 of the Indian Penal Code, which defines criminal intimidation as whoever threatens an other with an injury to his person, reputation or property, or to the person or reputation of anyone in whom that person is interested, with intent to cause alarm to that person to do any act which he is not legally bound to do, or to omit to do any act which that person is legally entitled to do. As the means of avoiding execution of such threat, commits criminal intimidation. If these words are to be interpreted in the light of computer technology, where computer is used as a tool, then cyber stalking is nothing but harassment through computers. The only difference being that internet gives the offender an anonymity which prevents him from being detected easily. But the end result is same. There is intimidation, harassment. So, a criminal can well be booked under section 506 of IPC for committing cyber stalking. Then we will discuss data theft and theft of internet hours. Section 43B of the Information Technology Act 2000 defines data theft. What does data theft means? Downloading data, information stored in a computer through internet without the permission of the owner or any other person who is in charge of a computer system or computer network. Another ingredient is downloading copies of extract any data, computer database or information from such computer network or computer system. The section makes the person liable to pay damages by the way of compensation not exceeding rupees 1 crore to the person so affected. Section 378 IPC defines theft as whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. As far as this definition is concerned, it can well include every type of theft with the help of computer, as computer data information is movable property and downloading of data can well be said as moving the property in the context of section 378. Theft of internet hours refers to using somebody else's internet hours. Section 43 subclause H of Information Technology Act 2000 lays down civil liability for this offence. It reads as whoever without the permission of the owner or any other person who is in charge of the computer system or computer network charge the services availed of by a person to the account of an other person by tampering with or manipulating any computer system, computer network is liable to pay damages not exceeding 1 crore to the person in office. Then we will discuss cyber forgery and frauds. Forgery is a creation of document which one knows is not genuine and yet projected the same as if it is a genuine. Section 464 of IPC defines forgery as the making of false document with intent to cause damage or injury to the public or to any person. In digital forgery, a document is prepared by making use of digital technology. Section 464 of the IPC was amended by Section 91 of the Information Technology Act 2000 to include a false electronic record. Section 29 has been inserted in the Indian Penal Code to provide for the definition of electronic record. Section 29A shall have the same meaning as Section 21F of the Information Technology Act. Frauds through internet are definitely a resemblance of white collar crimes. Since the inception of computer technology, there is a dramatic rise in the number of cyber fraud cases. Internet fraud may be broadly defined as any fraud committed through or with the aid of computer, programming or internet related communication such as websites, emails and chat rooms. Majority of the scams and the frauds through computers are related to investment. Internet offers certain unique advantages which no other medium has, like anonymity and speed. The internet also offers a global marketplace for consumers and business. These factors together work up to make a heaven for any fraudulent activity online. There are various sum of common internet frauds which includes online auction, advance fee loan, work at home plan, travel and prices, other online frauds and other financial crises. Identity theft and frauds are crimes where someone wrongfully obtains and uses another personal data in a way that involves fraud or deception for financial gain. To avoid these type of offences, giving of personal detail to others should be avoided. Another category of money related crime is credit card frauds. Here again, somebody's credit card may be wrongfully used for one's personal gain. This risk has grown multifold as people do purchasing online through their credit cards. The websites offering products take all the detail of credit card and store information on the server. So anybody who can access the server can use the credit card details for financial gains. Apart from this, financial frauds includes market manipulation scheme, issuance of false stock, online gambling, sale of illegal articles. The word fraud has not been defined in the Indian Penal Code. However, Section 25 of Indian Penal Code defines the word fraudulently, as there can be no fraud unless there is an intention to defraud. Wherever the words fraud, intent to defraud or fraudulently occurs, the definition of a crime under IPC, two elements at least are essential to the commission of that crime. The one is deceit or an intention to deceive, another is either actual injury or possible injury or intent to expose some person to the actual or possible injury. So, we can say that the definition of fraud encompasses within its fold to the scams on the internet. Both are essential requests of fraud. There is deceit or intention to deceive and actual or possible injury to an other individual are present in all such scams, intended to gain advantages at the risk of the loss to the others. Then we will discuss cyber pornography. Availability of obscene material. Obscenity refers to stimulating sexual or other erotic activity over the internet. It includes pornography websites, pornography magazines produced using computer to publish and print the material, and the internet to download and transmit pictures, photos, writing, etc. Information technology has made it very easy to create and distribute pornographic material through the internet, and these materials can be transmitted to the entire world network within seconds. In the preceding decade, there is a sudden rise in pornographic crimes, reason being the easy access of the pornographic material online and its anonymity. People can watch thousands of pornographic pictures in the privacy of their homes. Section 292 of the IPC deals with the nature of obscene material as a book, a pamphlet, a paper, a writing, drawing, painting, representation, figure or any other object shall be deemed to be obscene if it is that appeals to the prurient interest of its effect or the effect of any of its items if it taken as a whole, such as to tend to deprave and corrupt persons who are likely having regard to all relevant circumstances to read or hear the matter contained or embodied in it. Other traditional laws dealing with this issue are Indecent Representation of Women's Act 1986, Young Persons Harmful Publication Act 1950, people dealing in cyber pornography that is accessible to the persons under the age of 20 years are liable to be prosecuted under Section 293 of IPC. Section 67 of Information Technology Act 2000 also deals cyber pornography where publishing of information which is obscene is punishable. Child pornography is also gaining popularity due to the availability of material from all over the world. Article 9 of the Cybercrime Nation provides punishment for child pornography. It is so whoever commits intentionally and without right thing conduct producing child pornography for the purpose of its distribution through a computer system, offering or making available pornography through a computer system, distributing or transmitting child pornography through a computer system, or producing child pornography through a computer system, processing pornography in a computer system or on a computer data storage medium will be considered as a child pornography. In concluding remarks, I must say the aforesaid discussion concludes that the provision of the Indian Penal Code seems to be sufficient to deal with almost all type of criminal activities through computers. The use of our penal code to prosecute cyber criminal has recently got a new dimension in the form of Information Technology Act 2000, which contains some specific offences and penalty for the same. The Act has also effected some important amendments in the Indian Penal Code, but the IT Act itself suffers some shortcomings which need to be cured. Thank you viewers for watching this program.